If a landlord sues a tenant for anticipatory breach of a lease, does the landlord have a duty to mitigate its damages by attempting to relet the premises? We explore that question in Austin Hill Country Realty versus Palisades Plaza. Palisades Plaza owned an office complex. Barbara Hill, Annette Smith, and David Jones operated a real estate business through Austin Hill Country Realty. Hill Country entered into a lease agreement with Palisades. The parties also entered into an improvement agreement under which Palisades agreed to renovate the leased space for Hill Country's use. The lease was to commence on the date Hill Country moved in or on the date Palisades substantially completed improvements to the space or would have done so but for tenant delay. After completing substantial renovations, Palisades received conflicting instructions from Hill, Smith, and Jones about how to complete the work. Palisades sent several letters requesting that Hill, Smith, and Jones designate a single representative to make decisions on their behalf. Those letters were ignored. Palisades then sued Hill Country in Texas State Court for anticipatory breach of the lease. At trial, Hill Country introduced evidence to show that Palisades failed to mitigate its damages. Hill Country also asked the trial court to instruct the jury that Palisades' damages should be reduced to the extent Palisades could have mitigated its damages through the exercise of reasonable care. The trial court rejected this request and held that a landlord has no obligation to mitigate damages. The jury found in favor of Palisades. The Court of Appeals affirmed. Hill Country appealed to the Texas Supreme Court.